Hello and welcome to the BPA Cast, the podcast by Di Blasi Parente e Associados, where we explore the world of intellectual property through a global lens. I'm Gabriel Di Blasi, founding partner of the firm, and your host for today's special episode. Today we have the pleasure of welcoming Mr. Tomoya Kurokawa, Vice President of Soi Patent Law Firm, one of Japan's most respected IP firms. Well, we will discuss how Japan leverages design rights to protect technology. And I will share some insights on how Brazil systems compares. Mr. Kurokawa, welcome. It's an honor to have you with us.
I'm happy to be here, Gabriel. Thank you for having me.
To begin, could you give our listeners an overview of how design rights are used in Japan to protect innovation technology?
Thank you, Gabriel. In Japan, design rights are not just about aesthetic. They are a powerful tool for protecting the shape, patterns, and even graphical user interfaces of products. In recent years, the Japanese Patent Office, called JPO, has expanded the scope of design protection, allowing more technological and digital elements like UI, UX, and icons to be protected. This is crucial for tech and electronics companies.
Fascinating! For Japanese innovators and global companies entering the Brazilian market, it is important to file design applications early and ensure the novelty and originality of design. Since in Brazilian design registration are granted without prior substantive examination, a request for merit examination must be made before enforcement to ensure full legal protection. Ms. Kurokawa, could you elaborate on how design rights complement patents in protect technology in Japan?
In Japan, companies often file both patents and design applications for the same product. For example, while a patent may protect the functional mechanism of the product, the design registration can protect its appearance. This dual strategy provides a broader umbrella of protection. It is valuable not only in consumer product but also B2B product such as industrial parts.
Yes, and in Brazil we recommend a layered IP strategy combining patents and design rights to provide broader protection for technology. Patents, to better understand, protect the functional and technical aspects, while design rights safeguard the visual appearance of products. This dual protection is especially valuable in industries where both function and aesthetics are important. Mr. Kurokawa, are there any recent legal developments in Japan related to design rights and our audience should be aware of?
2020, Japan enacted a major reform expanding the scope of protection. Now, even interior designs and building designs can be registered. Also, graphic images like just a portion of a screen of device can now be protected. This is especially relevant in the age of smartphones and smart devices.
That's significant evolution. In Brazil, it's recently enhanced its design rights framework by joining Hague Agreement in August 2023, enabling international design filing through WIPO. Additionally, the country's national IP strategy, MP, prioritizes faster and more transparent design examinations. Mr. Kurokawa, how effective is design enforcement in Japan? Our company uses design rights aggressively in litigation licensing.
Japan has seen a rise in enforcement cases, especially in industries like fashion, electronics, and automotive. While the number is still smaller than patent disputes, companies are increasingly recognizing the commercial leverage design rights provided. It is because, first, quicker examination. It takes less than 7 months from filing to registration in average. Second, higher grant rate. It is 85%. And third, easier enforcement. That is, pointless technical discussion less likely in legal dispute.
That's inspiring. In Brazil, enforcement is improving, but still slowly. The number of infringement lawsuits based on industrial design rights remains relatively low. One of the reasons is that design registrations are granted automatically without a prior substantive examination of novelty and originality. Although this technical examination can be requested later, it is essential to ensure the full legal enforceability of the rights, especially in court. As we close, what advice you give to Brazilian innovators or global companies entering Japan marketing regarding design protection?
Okay, I'd say don't underestimate the value of design rights. They are first, cost-effective, and can serve as a strong IP weapon. For companies expanding into Japan, securing design rights early, especially for visual elements, can prevent costly dispute and offer a commercial edge.
Excellent advice. I fully agree. To succeed in Brazil, Japanese innovators and global companies should file design application early, ensuring novelty and originality. Mr. Kurukawa, thank you for this fascinating conversation and for sharing your expertise and knowledge on Japan's forward-thinking design practice.
Thank you very much, Gabriel. It was my great pleasure.
And thank you to our listeners to joining us on DBPA Cast. Stay tuned for more cross-border conversations on intellectual property. And don't forget to follow us on your favorite podcast platform to never miss any episode. Bye-bye.